Dr. Jones, you just talked about root causes, and as you said it, I thought, yes, that is actually the key. I mean, we've got, according to the UNHCR, Simon will correct me as he once did on a previous occasion about the numbers, but I read recently, but it's about 110 million people who are displaced in the world at the moment. Yeah. And thinking about that, it takes us back to what Mr. Solomon was saying, really, about where we've been before. And in the aftermath of the Second World War, the last time we had such a huge number of people displaced and having to both accommodate but rebuild their lives, and the international community stepped up, and everything from Bretton Woods to the Marshall Aid Programme to the creation of the Iron and Steel Community and the Universal Declaration of Human Rights 75 years ago, and the Refugee Convention in 1951. Winston Churchill took us into those treaties, those conventions, because he said the world has to step up to the plate. We have to be part of the solution. And it imposes upon us collective responsibilities. And I want to ask you first, if I may, and then I'll ask you about the convention duties, because our mandate as a committee is particularly to look at our obligations under the ECHR. But first of all, under the 1951 Convention on Refugees and the need for us to act collectively, what effect will this have on those obligations, this bill? What effect will it have? Will it be negative? Is it possible to comply with those obligations or not?
Well, both the Court of Appeal and the Supreme Court said there's nothing incompatible with the Geneva Convention in returning somebody to a safe third country. So obviously the question isn't, is this compatible with the Geneva Convention? Is Rwanda a safe country? In terms of international conventions and humanitarian obligations, you've got to remember many of these conventions and treaties were created, in the aftermath of the Second World War and during the Cold War, and these treaties were aimed at much smaller groups of people. They were aimed, obviously, at refugees from Nazi Germany. They were aimed at refugees from the Soviet Union and the various satellite states. So many of the issues we have now, global communications, aviation that's accessible to everyone, really quick transport, and people on the move constantly, that wasn't anticipated by the people who drafted the legislation. So, non-refoulement was aimed at refugees from behind the Iron Curtain, because if they were sent back, they'd be detained, interrogated, they'd have a confession taken out of them, and they'd either end up dead or in a gulag. So these laws were created for a very different time and place, and the key question is, are they compatible with the world we now live in post the Cold War?
Well, not just the world, but our duties. Mr. Steele.
Yes, I might say I take a slightly different lesson from the post-World War II settlement in terms of the various treaties, obligations and conventions that flowed out of that, with respect to the fact that I think at its core was this recognition, or the aim to recognise the inherent dignity and value of every single human being born out of the horrors of what had happened. And I think that's when we talk about having a salami slice tactics approach to whittling away human rights for this particular group or that particular group. It's obviously in the context of the Rwanda bill. We've seen it in the Illegal Migration Act with respect to Section 3, also the Victims and Prisoners Bill, which I think is just going into the House of Lords at the moment. There has been this consistent attempt to try and undermine and separate particular groups, especially vulnerable groups, I might add, from these overarching protections. And I think at its heart, we have to remind ourselves of the importance of that kind of inherent dignity point. With respect to the Refugee Convention as well, I think underpinning that too is this principle of global solidarity and responsibility sharing, which makes the system work properly. And I think going to the suggestions that Mr. Solomon made earlier, the multifaceted approach that would be needed to address this issue in an evidence-based manner, we have to ask ourselves, well, firstly, is international cooperation necessary and important for that? I would argue yes. And then secondly, does this bill and our approach to international treaties, to international law, make it more or less likely that other countries are going to interact with us in a productive and useful and trustworthy way? And again, I would argue that it damages that in that respect.
Turning to the convention duties now for a moment as well, and I'd like to ask Mr. Solomon and Ms. Bandelman perhaps to answer this. We were disappointed as a committee that Suella Braverman did not come before the committee to justify her decision not to provide a compatibility statement, to give us an explanation as to why that was the case. Do you think that there are amendments that can be laid and are being laid? And indeed, we heard reference earlier on to Mr. Lawton, who was on his feet while we were mentioning him during the debate in the Commons at this very moment. If amendments are made to this, do you think it is actually possible for us to come into a place where the Secretary of State could sign a compatibility statement? And do you think that is necessary anyway? Is this a desirable thing to do? And do we need to act in concert with others who are subject to that treaty still at this time, to the European Convention on Human Rights?
Well, I think it's important, if you're committed to a rights-based approach and to the Convention, that you ensure all pieces of legislation are compatible. Otherwise, what's the point of signing up to that rights-based framework, international framework or convention? So absolutely, yes. I think on the question of whether this is the bill is compatible with the UN Convention on Refugees, not the ECHR, the UN Convention on Refugees, is often confused in these discussions. It is separate. I would argue it is not, and that was the clear judgment of the UNHCR, which is the international arbiter of the convention. Our domestic courts disagreed with that. Their interpretation was different, but the UNHCR's view was very clearly that it does not, it is actually in conflict with the convention. And my final point is a very simple one, actually, and I think this goes to the heart of who we want to be as a country. I do not think, as of this day in 2024, it is outdated to want to protect someone from torture, or to provide protection to someone from human trafficking, or to provide protection from someone who is fleeing a conflict that they have been caught up in through no fault of their own. Actually, I think that is the right thing to do, and that is essentially what the UN Convention on Refugees is about. That is why we signed it, and that is true today as it was 10 years ago, as it was 20 years ago, and as it will be in 10 years' time, 20 years' time, or 30 years' time, because that goes to the heart of our worldview and our view of a collective humanity with a collective responsibility to provide protection to victims of heinous abuses.
Thank you. Perhaps Ms. Panterman, you'd also address this.
On the statement of incompatibility point, or statement of compatibility, I would draw the committee's attention to what Lord Irvine, then Lord Chancellor, said on the 3rd of November 1997, when the Human Rights Bill, as it then was, being debated in the House of Lords, which is that where a statement cannot be made, parliamentary scrutiny of the bill would be intense. Now, for this bill, as for the illegal migration bill, as it then was, scrutiny has not been intense, and we can see from the debate that's currently ongoing that the debate is taking place in committee of the whole House. And that is different from the type of scrutiny to which the Nationality and Borders Act 2022, for example, was subjected to. So I think it is crucial and fundamental to make further inquiries in relation to the Section 19(1)B statement that we have in relation to this bill. And of course, in relation to the Refugee Convention, this bill, together with the Illegal Migration Act, building also on the Nationality and Borders Act 2022, puts at risk the very question of access to territorial asylum, and it puts at jeopardy the UK's compliance with its international legal obligations under the Refugee Convention. And I'm sure my colleague Dr. Jones will wish to correct the record at some point in relation to the Supreme Court not turning its mind to the question of Article 31 of the Refugee Convention in the way that the Court of Appeal did.
Thank you very much. Thank you, Chair.